Hi, I'm David Himmelfarb, Managing Partner at Himmelfarb Brzezinski, and today I've been asked to put together a presentation for you all, and it's in relation to a guide to provide you with knowledge, practical knowledge, on WSIB claims, appeals, and the electing out process that is at the WSIB. There's a few objectives that we have today. To increase your practical knowledge of WSIB claims, the appeals and the electing out, obviously, to ensure that WSIB patients receive care and compensation that they rightly deserve, and to challenge each and every one of you in this room to think about someone that you know who can benefit from this presentation. So, first and foremost, what is the WSIB? Which is previously known as the Workers' Compensation Board. Well, the Workers' Compensation Board, the WSIB, it oversees employment, safety, education, and training. Provides compensation and benefits to eligible claimants that are injured on the job, and provides an exclusive adjudication system for all claims and an appeal process for both workers and employers. The system itself has been set up since about the 1920s, when we went into a no-fault system of compensation for any accidents that occurred in the workplace. And in exchange for the right to sue, any worker who is involved in an accident, regardless of fault, is entitled to workers' compensation benefits. Who is eligible for WSIB benefits? First of all, you actually have to be covered by the Act in order to be eligible for WSIB benefits. So you must suffer an injury, and it must be a work-related accident in order for you to be covered by the Act. The legislation that applies is the Workplace Safety and Insurance Act, and Section 13.1 of the Act sets out that a worker who sustains a personal injury by an accident arising out of or in the course of his or her employment is entitled to benefits under the insurance plan. There's two types of workers under the legislation. They've divided workers up into two schedules, Schedule 1 and Schedule 2. Schedule 1 are basically all types of industries divided into 9 subclasses. These are all types of industries that we know of, manufacturing, transportation, etc. Schedule 2, these are injuries which are self-insured, so that means that they actually pay out the claim themselves. They're generally governmental in nature, and we'll get into the distinction between the two schedules shortly. So in terms of Schedule 1, we've got forest products, mining and related industries, other primary industries, manufacturing, transportation and storage, retail and wholesale trades, construction, government-related services, and other services. Schedule 2, railways, telephone companies, telegraph companies, navigation companies, international bridges, provincial governments, airlines, municipalities, public library boards, police villages, and school boards. So if you're under either of those schedules, if you work as a worker under an industry covered under Schedule 1 or an industry covered under Schedule 2, and you're injured while working, you have an accident-related, a work-related accident injury, then you are prima facie covered by the Act, and you're entitled to the compensation under that Act. What also happens is that you are not entitled to sue your employer or your coworker for causing your injury as a result of your accident. The Act, the WSIB, actually takes that away from you. And we'll get into, in a little more detail, how to elect out of the WSIB in certain situations. So we just covered the schedules, Schedules 1 and 2, anyone identified in those schedules are covered as workers, and those who are not eligible. They're not covered under the definition of worker under the Act, or they're not in an industry that's covered in Schedule 1 or 2. So there's only, there's a vast amount of industries in Schedule 1 or 2, but there are a number that are not covered in Schedule 1 and 2, and we'll show you that in just a moment. So worker is actually defined under the legislation, and it defines a person as being a worker who's entered into or is employed under a contract of service or apprenticeship. And basically it's a legal test that must be applied to determine whether the injured party is covered by the Act. For instance, independent contractors are not workers under the legislation. So the legislation would not apply to someone who may be an independent owner-operator of a transport truck. In that situation, the person who's driving the transport truck, the independent owner-operator, would not be a worker under the WSIB legislation, and therefore prima facie would not be entitled to coverage under the Act. What does that mean on the other flip side of the coin is that that person is entitled to make a lawsuit. That person is entitled to sue the at-fault driver who caused the collision and entitled to compensation that the courts provide. There's also some further delineation in terms of who is a worker. There's further definition. Executive officers of companies are not workers. Independent business operators are not workers. Sole proprietors and their spouses are not workers. Partners in a business, volunteers, at-home workers, and casual workers. All these people would not be covered by the WSIB, and they would be entitled to a legal action if they were injured while they were actually doing work. Now, to give you some frame of reference, we're referencing here a case that actually I was involved in called Nagalingam and Rampino. This is a decision from the Workplace Safety Insurance Appeals Tribunal. And our client was a taxi driver who was struck by a coach bus, and he was very, very seriously injured. Both the taxi driver was working at the time of the accident, as was the bus driver. Both were in Schedule 1 industries. So right off the bat, we would think that, well, that's it. This poor taxi driver who's really badly injured would not have the right to sue the bus driver and its company for compensation. But when you look at whether or not the taxi driver is actually an employee, a worker, or an independent operator, if you can determine that the person is an independent operator, then they are not covered by the Act, and therefore they have the right to sue. And in this particular case, the tribunal held that our client was an independent contractor and not an employee. And therefore he was permitted to continue his lawsuit against the bus driver and the company, and was very successful. He got much more compensation in the court system than he would have ever seen in the WSIB areas. There's another example here. This was a private ruling from the board. Again, another case that we were involved in. Mr. S was the owner-operator of a used automobile dealership. He attended the automobile auction to purchase vehicles. While there, he was struck and he was killed by a vehicle that was entering into the auction. And in that case, because he was there on behalf of his company, he was actually working at the time. He was going to be buying vehicles at the auction. And he was certainly struck by someone who was working for the auction company at the time. Normally, that person would not have the right of action. But when we looked at the situation more more clearly. We were able to find out that he was actually the officer of his own corporation, and therefore, as we showed you previously, he'd be excluded from coverage under the Act, which then allows him to be able to sue the auction company for compensation. And it was really Mr. S passed away, unfortunately, in the accident. It was his spouse and children that made the claim against the auction company. We recently settled that case for, it was almost $2 million for them. There's no way that they would have received anything close to that if it was kept within the WSIB system. There are some omitted industries as well. And the Act, the WSIB Act, it just doesn't cover these industries. So if you're actually working and you suffer an injury while you're working, and you work in these industries that are omitted under the Act, then you're not going to get WSIB benefits anyway. You will prima facie have the right to sue. And those industries, banks, insurance companies, trust companies, credit card companies, financial institutions, law firms like my law firm, real estate agencies, business associations, recreational social clubs, live performance theaters, trade unions, private schools, recreational and vacation camps for kids, travel agencies, and health clubs. So anyone who works for any of these industries involved in an accident, they are entitled to sue their employer for negligence because these industries are completely omitted from the Act. Big gaping hole for all of those industries in the legislation. There's other ways to get through the purview of the Act or the coverage of the Act on you. Because our goal as lawyers is if we can exclude you from the coverage of the WSIB Act, then we'd like to be able to do that because compensation in our courts is much better than having to go through board doled out compensation. The WSIB is a no-fault piece of legislation, and it does not come anything close to what our courts will provide accident victims with in terms of appropriate and legal compensation. So our goal is to try and get as many holes, many areas in the Act as possible to allow people access to the courts. Another way of doing this is to determine that the person was not in the course of their employment at the time that the accident happened. Now this is, it's a legal test, and it determines whether or not you're entitled to benefits. Because the Act actually says that your injury must arise out of and in the course of your employment. There's 3 factors to be considered: place, time, and activity. Obviously, if you're at work during work hours and you're doing work-related activity, the likelihood is that you are in the course of your employment. Well, what happens if you go out for lunch? You're technically still at work. You may have gone off premises. You may be on your own lunch hour. Well, now we get into gray areas where you may not actually be within the scope of your employment or the course of your employment at the time that your injury occurred. There's an example. For instance, we touched on this briefly. Are you on the employer's premises? Is it during work hours? Are you doing a compulsory task away from the workforce? Are you on employer's conveyance? Is it in an ownership? Are you in an owned parking lot? All these sorts of things are looked at when the tribunal determines whether or not you're actually in the course of your employment. Here's a case that called a day and Extendicare. This is a case that we were involved in where our client was a nurse at Extendicare, and she had essentially left a little early that day, and she had gone into the parking lot, gotten into her car, and she was about to leave and she was turning left from the Extendicare parking lot onto the highway when she was broadsided by another vehicle. And this woman was very, very seriously injured. She was an incomplete quadriplegic. And she would have been covered by the board. The first impulse from everybody, including the insurance companies, was this lady was basically just leaving her place of employment, and she should be covered by the WSIB. But we were able to prove at the tribunal level that the accident actually occurred not on the employer's property, but on the highway. And even though we were taking the position that her vision was blocked by the employer's own mailbox, which they owned and maintained and was on their own property, we were taking the position that that mailbox was placed in such an area that it would have blinded people of oncoming traffic, as it did in this particular case. The long and short of it was that we were able to prove that this lady was not in the course of her employment at the time that the accident occurred, and therefore she was not covered by the Workplace Safety Insurance Act, and she was entitled to sue. And she got great compensation as a result of that. Just to reiterate, the recourse for those that are not covered, and we've given you numerous examples of that up to now, is that while the Act provides that workers cannot sue their own employers, there's all sorts of different ways to get around that. All of the areas that we've showed you up to now are ways to get around the coverage of the Act, because the Act only covers so many areas, and there's holes all over the place, and that's what we've been able to get people compensated for. There are concerns with the WSIB. Not everybody's covered, as we've advised. We all know that there's limited benefits, not enough to truly compensate people for the losses that they've suffered. It's government regulated and very difficult to navigate through. We've spent many hours dealing with people that are frustrated with the board process. Even candidates who qualify are denied benefits routinely. And it's like we told you before, it's a no-fault regime, and the benefits just are not anything close to what a court would provide you. There is an election process. If you are covered by both the Act and you do have an entitlement to sue, you can elect out of the board coverage and pursue an action against the at-fault person. So which workers have the right to sue? The standard rule, if you're covered by the Act, is you can't sue your own employer or any other employee or employer. There are, however, some very important distinctions between the schedules. So remember, we showed you those schedules. Schedule 1 with the 9 industries, Schedule 2 with a number of other industries. Two distinct schedules in the Act. Well, a Schedule 1 worker can sue a Schedule 2 worker or an employer. And a Schedule 2 worker can sue either a Schedule 1 or a Schedule 2 worker or employer. So that means that if there's an accident, a car accident, for example, and you have Schedule 1 and Schedule 2 workers in two separate vehicles, there is a lawsuit there. Those parties can sue and have access to the courts. So very important to determine what schedule the person is identified as right off the bat. And an example of that is perhaps a Purolator courier driver who's involved in an accident with a Bell Canada truck. And the Bell Canada truck driver is at fault. The Purolator courier driver is covered under Schedule 1. The Bell Canada truck driver is covered under Schedule 2. And the outcome would be that the Schedule 1 worker can sue the Schedule 2 worker And therefore, the perlator courier driver has the right to sue and has access to the courts and the appropriate compensation there. There are some situations where the worker may have a concurrent entitlement. In other words, being entitled to both the WSIB as well as having the right to sue. This refers to the worker's option of either making a claim for WSIB or opting to sue for pain and suffering and all other losses that they'd be entitled to receive in our court systems. This is referred to as an election to sue. For example, a worker employed as a truck driver gets involved in an accident caused by an at-fault driver who's not working at the time of the accident. So you have one person involved, the truck driver, he's working, the other car is not, no one's working, no worker in that car. So that person now has, first of all, he's covered by the act if he wants to, but because the other person is not in the course of their employment at the time that the accident happens, the truck driver has the right to sue, so he has an election. So what we do recommend is that the truck driver or the person who's involved in the accident elect out of the WSIB so as to have access to the court system and the better benefits there. There's another example. This is an example, by the way, that last example was another one of our cases, and this next example is also another example of one of our cases. A worker installing cable services in a new home slips and falls on icy steps as he's leaving and ends up sustaining traumatic brain injury. In that case, you have a man who's actually in the scope of his employment at the time, but the homeowner is not. They're not working. It's not a place of employment. So even though the technician, the cable technician, is entitled to get benefits from the WSIB, he also has the right to sue and elect out. In this case, the worker did elect out. We were successful in helping him do that, and we were also successful in settling his case shortly before trial. I may add that in terms of the compensation that he received, it was about 4 or 5 times as high as he could get from the WSIB. In terms of making that election, it generally must be done within 3 months of the accident date, so it's important for people to consult with lawyers who understand the WSIB system. Not a lot do. There's not many who have expertise in the area, and so it could make all the difference in the world for people if they get properly compensated, but they need to get into the right law firm for an appropriate opinion. So it's important for people where they may be working, or maybe the other person's working involved in the accident, to find a law firm for an opinion in relation to an election out of the WSIB, or even whether the Act actually applies to them. Elections are made through a form that's filed with the board called an election form and signed off by them. We've given an example of that. How do you know when an election is available and which election to make? Well, most people aren't going to really fully appreciate that. It's important to get some good legal advice. And we recommend that anyone who's seriously injured in an accident, while they may be working or the other person is working, get an opinion from a law firm that truly works in this area, that understands WSIB and the application of it. We're going to talk quickly about WSIB benefits. What do they actually offer you? Well, they give you loss of earnings, non-economic loss, which is sort of a pain and suffering award, but at a drastically reduced amount. There is loss of retirement income available in certain circumstances, future economic loss, some health care benefits, personal care allowances, etc. in terms of personal care allowance, there's policy in relation to it. There's an allowance that's provided to hire an attendant to provide 3 categories of care: skilled, personal, and general. And we've set out what the policy actually says. What this means is that the board actually follows a policy and they're rigid to it. So if you don't fit within the policy in terms of personal care allowances, then you won't get it, or you need to hire someone who can help you fight for it. There's also a home care policy. There is entitlement to home care when health professional indicates that health services are needed at the home. And there's a policy, again, that's provided by the board that we've set out here for you to take a look at. There's also vehicle modification policy. And what we've done is we've just taken a few of the policies in relation to some of the various items that we find are underutilized. If you're stuck within the board itself, many of our clients are WSIB clients. And what we do is, if we can't get them out of the purview of the Act, if we can't coverage of the WSIB Act, then we'll maximize the benefits that they're entitled to. So we've set out the vehicle modification process. There is an appeal process in the WSIB, and they'll make decisions. They may say that you're capable of a return to work, and therefore they're not going to pay you any more loss of earnings. So what happens? There's 2 types of denials. There's a denial of a benefit or termination of an ongoing benefit, and you can appeal by filing an objection form. And then you're entitled to an oral hearing or an appeal in writing. And thereafter, if that's unsuccessful, you can go to an independent tribunal called the Workplace Safety Insurance Appeals Tribunal. And what's the time limit for an appeal? 6 months. You don't want to go any further than that. So if you've been denied, you should be seeking legal counsel for an opinion to determine whether your appeal is viable. And ladies and gentlemen, that's the presentation for today. Thank you very much for listening and being attentive. Thank you.